to make one further administrative announcement, and that is to just sort of say that I will hold special office hours next Monday. That doesn't mean if you have a question, in case you have a question or a query when you're reviewing for your exam. And my special office hours will be from about 11:30 to 2 o'clock. So I'll do it over the lunch period, so in case people have an exam in the morning and they have a question, they've got that block of time, or an exam in the afternoon, they've got that block of time. So I think that that's probably the best block of time. So I'll do it from 11:30 to 2 o'clock. That doesn't mean you have to come in if you have a question or a query. It also means that I'm just sitting beside the telephone, and you can just phone in and we can talk about it on the phone. Email doesn't work very well, I think, because often there are questions that we really need to have an exchange, and exchange of words often are the best. So I will just hold extra office hours the day before the exam for anybody who has any questions or issues arising from your review for the exam. Again, that's next Monday from 11:30 to 2 o'clock. Okay? Okay. Are there any questions that you have for me, or is everybody, I guess by this stage, everybody is more or less whatever? Okay. Now you'll recall last week we were talking about fundamental breach, and we had one last case to do. That is the case of Turcon Contractors in British Columbia on page 537 of the case book. A case which I emphasized to you last week is an exceptionally important case, a really important case from the Supreme Court in 2010. Now, facts of the case were as follows. The facts are slightly complex, so we just have to sort of bear with me as we work through the facts, okay? The facts of the case were as follows. BC, the province, put out a tender for the design and construction of a highway through the interior of British Columbia. 6 construction companies, known in the law of tendering as proponents, so we'll just call them proponents. 6 proponents. Where's all the top going? 6 proponents. Six proponents submitted, yes.
What's the name of the case again?
Turcon, T-E-R-C-O-N, and BC, it's at the start of the, you got it?
Yeah, sorry, I just missed it.
Hey, okay. I start again? Okay. BC placed a tender for the construction of, the design and construction of a highway in the interior northern British Columbia, something like that. I'm not quite sure where it went. 6 construction companies, 6 proponents submitted bids. BC looked at the bids, and then they decided that the province itself would design the highway. And so it just made the decision that it would design the highway, but then put out a second tender, which was to be limited to the original 6 companies. So the original 6 proponents only were allowed to submit bids for the second tender. Now, the second tender contained an exclusion clause. And the exclusion clause, which we'll look at in more detail in a minute or two, but I'll just want to get the facts out just now, and it's at the top of page 538. The exclusion clause, I'll just do a précis of it just now. Essentially what the exclusion clause said was that there was to be no compensation for participating in the tender. There was to be no compensation, if there are any costs associated, no compensation for participating in the tender, whether one won or lost the tender. Okay, now, one of the bidders, one of the proponents, a company called Brentwood, B-R-E-N-T-W-O-O-D, a company called Brentwood, entered into a joint venture with another company. Prior to submitting its bid for the second tender. Prior to submitting its bid in the second tender. Now, the reason that Brentwood did that was that it had no experience in drilling and blasting. But this second company, which was not one of the 6 proponents originally, but this second company this company with whom Brentwood entered the joint venture did have experience in drilling and blasting, which apparently was necessary experience for constructing the highway. Okay, there were 2 shortlisted proponents, Tercon and Brentwood. And at the end of the day, Brentwood was selected by BC to construct the highway. Brentwood was selected by BC to construct the highway. Tercon was not happy, and Tercon therefore decided to sue British Columbia on the ground of breach of contract. Tercon argued that Brentwood was no longer an eligible proponent, no longer eligible to bid, because it had entered into this joint venture. The original terms were only the 6 proponents, the 6 companies themselves, not those companies with joint ventures with a 7th, 8th, or 9th company, but only those 6 companies could submit for the second tender. So Tercon argued that Brentwood was not eligible, that BC was in breach of the tender, breach of contract, and it sought damages for breach of contract. Now, the province, British Columbia's entire defense was the exclusion clause. The clause 2.10, which is set out on page 538. 2.10 and 538. And so let's just look at that clause a little bit more carefully. It says, except as expressly, and I'm just reading from page 538, except as expressly and specifically permitted in these instructions to proponents, no proponent shall have any claim for compensation of any kind whatsoever as a result of participating in this RFP, request for proposals, and by submitting a proposal, each proponent shall be deemed to have agreed that it has no claim. Well, the editors of the textbook have usefully italicized the key parts of that clause for you, and the key part, of course, is no proponent shall have any claim for compensation of any kind whatsoever as a result of participating in this tendering process. Okay? Now, I think those are pretty clear words. No compensation whatsoever of any kind. Okay, now, the case went to trial, and before the British Columbia Supreme Court, the trial judge made several findings. First, the trial judge found that Brentwood was not qualified by virtue of the joint venture. That Brentwood was not qualified. Secondly, that meant that BC, in continuing to consider them, that BC was in breach of contract. Thirdly, that BC was in fundamental breach of contract. Fundamental breach of contract. And fourthly, the trial judge also found that the clause was ambiguous. Okay? So the contra pro forentum rule would apply. That the clause was ambiguous. So finally, at the end of the day, obviously the trial judge found for Tercon and awarded damages to Tercon. Okay? The case was appealed to the British Columbia Court of Appeal. And the British Columbia Court of Appeal reversed the trial judge's decision and found for the province, found for BC. And they found for BC quite simply because they said the clause was clear, the clause was enforceable, and the clause said no compensation in any circumstances, so no compensation should be awarded in any circumstances. Okay? Okay, so the BC Court of Appeal, put all of its eggs into the interpretation of the clause, right? Clause clear. Clause says no compensation for participating in the bidding process, therefore no compensation to Terracon, even if they lost for losing the bid. Okay. Other issues we're not concerned about. It's just a matter of interpreting the clause. Terracon appealed to the Supreme Court, and it's excerpts from that Supreme Court decision that we have in front of us in the case book. The Supreme Court reversed the Court of Appeals decision. The Supreme Court said, found for Terracon. Okay? Found for Terracon by a 5-4 decision. So it was a very close decision. 5-4 for Terracon. Now in the case book we have excerpts from the majority judgment for the 5 written by Mr. Justice Cromwell, and the minority judgment written for the 4 by Mr. Justice Binney. And we're going to have to look at both what Cromwell says and at what Binney says. But before we do that, it's important, and one of the most important things that comes out of this case, one of the most precedential setting aspects of this case, is that all 9 judges agreed on the test for dealing with exclusion clauses and fundamental breach, which Mr. Justice Binney propounded. So we have to look first of all at the test. So the test coming out of this case is what's really important about the case. So we'll look first of all at what Mr. Justice Binney said about the test. Then we'll go back and see how the majority applied that test. And then we'll swing back to Mr. Justice Binney and see how Mr. Justice Binney applied the test that he pronounced. Okay? So we're going to swing back and forth from dissent to majority and back to dissent. Okay? Okay, so the first question then that we need to ask is, what is this test? It was a 9-zip decision that this is the test, okay? Indeed, at the middle of page 538, Mr. Justice Cromwell says, I agree with the analytical approach that should be followed when tackling an issue relating to the applicability of an exclusion clause set out by my colleague, Mr. Justice Binney. Okay, so there you have the statement, I agree with Binney's test. So 9-zip on the test. So the question then becomes, what is that test? And the test is set out in the first half of page 545 in the case book. The first half of page 545 in the case book. Mr. Justice Binney says, the present state of the law, and I'm going to read, and I do apologize, I know it's a little bit boring for me, this is not story time or bedtime or whatever, but I think it's really important just to look at the words this time around. The present state of the law, in summary, requires a series of inquiries to be addressed when a plaintiff seeks to escape the effect of an exclusion clause or other contractual terms to which it had previously agreed. The first issue, so it's a 3-part test. The first issue is whether, as a matter of interpretation, the exclusion clause even applies at all. Okay? So first we ask, is the exclusion clause part of the contract between the parties? And what does it mean? As a matter of interpretation, does the exclusion clause apply in the circumstances established in the evidence? He then goes on to say, if the exclusion clause does not apply, there is no need to proceed further with the analysis, right? The exclusion clause doesn't apply between the parties, so the ordinary rules about damages, etc. apply. He then goes on, if the exclusion clause applies, the second issue is whether the exclusion clause was unconscionable at the time the contract was made. Okay, the second inquiry then, is the exclusion clause unconscionable at the time the contract was made? And he emphasizes that this question of unconscionability has to do with the formation of the contract, not unconscionability in performance or at breach. So was it unconscionable at the time of formation? And then Thirdly, he goes on to the third part of the test, and he says, excuse me, if the exclusion clause is held to be valid and applicable, the court may undertake a third inquiry, namely whether the court should nevertheless refuse to enforce the valid exclusion clause because of the existence of an overriding public policy, proof of which lies on the party seeking to avoid the enforcement of the contract, that outweighs the very strong public interest in the enforcement of contracts. So the third question, the third inquiry that is to be made according to this test is whether or not there is an overriding public policy at the time of the breach. An overriding public policy at the time of the breach, which outweighs freedom of contract, which outweighs freedom of contract. Okay, three-part test for dealing with exclusion clauses and alleged fundamental breach of contract. First, interpret the clause. Does it apply? What does it mean? Second, at time of contract formation, was there unconscionability between the parties? Third, at the time of the breach, was there an overriding public policy which overrides freedom of contract? Now, Mr. Justice Binnie does not define unconscionability. Mr. Justice Binnie does not define public policy. But we assume that he was simply referring to the way in which those words are normally used in contract law. That's the assumption which we tend to make. And after I talk about this case, as we move on in class, I'm going to be talking about both of those quite extensively, so bear with me, okay? Cross-reference your notes. Okay, so that is the test. Now the question becomes, how does the majority apply the test? How does the minority apply the test? So we'll swing back now to Mr. Justice Cromwell's decision for the 5 judges who were in the majority at the court. Now, Mr. Justice Cromwell begins, first of all, by adopting Binnie's test. Okay, we've already seen that. Page 538, he adopts Binnie's test. Then secondly, he looks to the clause and he interprets the clause. The first question in Binnie's test, what is the interpretation of the clause? And here he does something interesting, and in my ever so humble opinion, wrong. But what he does is he essentially asks himself the question, was there participation in the process, in the tendering? And he answers that question by saying, the process was unfair. The process was unfair. Therefore, there was no participation as required by the clause. The process was unfair. Now, why does the find that the process is unfair? He said the process was unfair because Brentwood was allowed to do this joint venture, and so there were really 2 companies under the wearing the hat of the one proponent, Brentwood. Okay? So Mr. Justice Cromwell says that is unfair. So he then goes on to say that because the clause includes an implied term of fairness, because the clause includes a required term of fairness, and because there was no fairness in the process, the clause does not apply. It only applies where there is a fair process. Okay.
Sorry, can you repeat the last one?
Yes. He said that because the process was not fair, and because he implied a term into the clause of fairness, of good faith, however you want to define it, he applies that into the clause. He says, well, this wasn't a fair process because Brentwood had a joint venture. Therefore, the clause does not apply. Therefore, Terracon gets damages, right? There's the trajectory of that. And thirdly, he then goes on to say, but even if I'm wrong on that, I think the clause is ambiguous. I think the clause is ambiguous. Okay. Apply the contra proferentum rule to the clause, and of course it has to be applied in favor of Terracon. It has to be applied against the proferens, who was British Columbia. Right? So he holds then for Terracon at the end of the day. Now the key to the majority's decision, the key to Mr. Justice Cromwell's decision is his willingness to imply a requirement of fairness into the exclusion clause. There must be a fair process, and then saying it's not a fair process when an extra party is allowed to be a part of one of the proponents. Okay? And again, one might question whether that is true as well, but that's not dealt with. So he holds for Terracon. So he interprets that word participating in clause 2.10 as meaning participating in a fair process. Please note, fair process is not in the clause at all. It just says participating. Which then brings us to Mr. Justice Binney's decision. And Mr. Justice Binney interprets the clause, the word participating, to mean participating. He says participating means participating. Fairness is not to be implied into the clause. Nothing about fairness in the process. Okay? So he applies his first inquiry, a matter of interpretation. He says, what does the clause mean? It just means participating. That's all. Nothing about the fairness of the alleged fairness or unfairness of the process. So, he interprets the clause. The word participating means participating, period. Second, he then goes on to ask his second question. Was there unconscionability at the time the contract was made? And his third question, was there an overriding public policy at the time of the breach? And he answers both of those questions in exactly the same way. He said, look, there is no unconscionability and no overriding public policy. Why? For the same reason. Terracon and BC are two sophisticated commercial parties. Terracon has even done other construction work for BC. It's won other bids in the past. Both parties know how the game is played. Both are sophisticated commercial parties. There can be no unconscionability when you have sophisticated commercial parties undoubtedly negotiating through their lawyers this deal at arm's length. Okay? Okay? You're on your own, bud, Terracon. You're on your own, bud, BC. You agreed to this agreement, this contract, you're bound by this contract. If you didn't like it, don't participate. Okay? So Mr. Justice Binney says no unconscionability, no unequal bargaining power between the parties, two sophisticated commercial parties, no overriding public policy. We enforce freedom of contract between commercial parties. We have freedom of contract between commercial parties, the fundamental rule of our contract law in the common law. Okay? So the minority then holds for British Columbia and finds that British Columbia ought to have been able to shield itself from liability by the clause. Okay? Okay, now, let's just sort of step back for a minute or two from the decision and consider a little bit about what it means for the law of contract and for exclusion clauses in fundamental breach. Well, the first thing to note that it only applies where we have commercial agreement between two commercial parties. It doesn't apply where one party is a consumer. So all of the law that we talked about last week, where it's a retail, a business manufacturer on the one hand, on the one side, and the consumer on the other, continues to apply. All that applies, right? overriding factors can come to the assistance of the consumer. Any consumer protection legislation which declares exclusion clauses null and void can come to the assistance of the consumer, et cetera, et cetera. And that's fine. So we're only dealing here with parties, contracts made by parties who are commercial parties negotiating at arm's length with one another. Secondly, and the second important thing is that there is agreement about the test in that context. The three-part test that Mr. Justice Binney applied. Okay? The third comment that I would make is that please note that in the discussion, the courts did not talk about fundamental breach. The trial judge said there was fundamental breach because the trial judge was deciding the case before the Supreme Court decided the case, right? So the trial judge was bound by the earlier case law, had to find fundamental breach, therefore exclusion clause not applicable. But the Supreme Court, in fact, Justice Cromwell says very early on in his decision, let's just put fundamental breach to bed. Let's not talk about it anymore. Really, the only question is, what does the clause say, and does it apply to the facts that happen? What does the clause say, and does it apply to the facts? We don't have to interpolate that extra step of trying to figure out whether the breach was fundamental or not. Not necessary. What was the clause? What were the facts? Does the clause apply to the facts? End of story. We don't need to characterize the breach in any way. Okay. Fourthly, it is questionable that Mr. Justice Cromwell's approach of implying terms into the clause actually represents an improvement or a change in the law. That's what Lord Denny used to do when he had a fundamental breach case, when he had an exclusion clause. He would imply terms, he would imply good faith, or he would imply whatever was necessary into the clause. And then say, clause doesn't apply, therefore I can award substantial damages. I would suggest to you that that is exactly what Mr. Justice Cromwell has done here. He has not changed the approach of the court. So the approach of the court is still like that of Lord Denny. Okay? We can interpolate our own clauses or our own concepts into the exclusion clause and then decide whether we are going to enforce that exclusion clause that we just made up for the parties. Okay? We just made up an exclusion clause to the parties. They didn't negotiate an implied term of process or good faith or whatever, how we want to characterize it, into the clause. What he did was essentially he redrafted the exclusion clause for the parties. He redrafted it for the parties and then found that his clause was breached and therefore could award damages. Okay? Okay. But Mr. Justice Binney did not do that. He took the clause on its literal meaning. He just applied the strict construction rule and said participating means participating. It can be a fair process, it can be an unfair process. Sophisticated party entered these kinds of contracts with BC, knew what they were doing. If it was unfair, they shouldn't have proceeded. It was for them to make that decision, not for me to make that decision. Okay, so this is a case then that is chock-a-block with quite a lot of legal significance. Now the case was decided in 2010, and obviously it has been considered by lower courts since. So obviously the next question is, well, how have the courts treated the Terracon decision? Well, whenever they have exclusion clauses between commercial parties, they do certainly refer to Terracon, and they dutifully cite Mr. Justice Binney's test, and they say, now I will apply the test, etc., etc. But a funny thing happens when you look at the case law, and there are now several hundred of these cases. I can't promise you or honestly say to you I've read all of the several hundred, but I read a good number to get a sense of where the case law is going on this. But I can tell you that in fact, fundamental breach keeps creeping in here again. the court says, other courts keep saying things, oh, well, there was a fundamental breach of contract, therefore cannot rely on exclusion clause. In other words, the courts are doing what Cromwell did. They are redrafting the clause themselves, not taking the clause that the parties negotiated, but are taking their own redrafted clause and enforcing or not that clause. So really, we're really right back at car sales and Wallace. That's what Lord Denning did in the case of car sales and Wallace. We're really right back to 1956. So, question, has there been a big change in the law? Well, all of the advertisement and the puffery around this case is really, really important case. Okay? Big change in the law. I'll take your question in a sec. Big change in the law, really important case. But we might doubt that. We might doubt that in light of how Mr. Justice Cromwell dealt with the decision. Okay, I'll just take one question because we need to move on. I have material to cover before, and I don't have another class in which to cover it. So just one question, this lady.
So the final rules of court was that there was no questionability of whatever that is.
There's no what?
Unconscionability.
Unconscionability? Thank you.
Yes, unquestionable, and that there was no overriding policy because both parties are
Yeah, they never,
supposedly-
the majority decision never went on to the second and third parts of Benny's test. That's correct.
And also too, you talk about like implied terms. So did the
That's a
judge-
second question. I said only one question. Go ahead.
Okay. So
Quickly.
Okay. You talk about like implied terms of fairness. So did the court actually consider that when to sign the decision, the final decision?
Sorry, can you just repeat that again?
So like you talk about like implied terms of fairness. So did the court consider that in the decision when they're
The court considered fairness, yes, that's right.
so
And they said it was unfair because Brentwood had entered into a joint venture.
Okay.
Okay? Okay. Okay, that essentially is everything that I wanted to say about the elephant in the room, okay? Really just to alert you to the fact that we can talk about freedom of contract and we can talk about all the rules of offer and acceptance, and they are all good law and the courts continue to apply them. But just remember that many of the contracts today that we make are contracts of a standard form, and they've got all sorts of nasty clauses lurking in them. But also I want you to know that the courts first and then the legislatures secondly are aware of that and have devised rules to try and rebalance or redress the bargaining imbalance which the use of these standard form contracts create in the marketplace for consumers. But for commercial parties, freedom of contract is the rule. Freedom of contract remains the rule. Commercial parties negotiating at arm's length are expected to take their knocks, to be big boys and girls, and to be responsible for the contract that they agree to. End of story. Okay, now you may recall in the very first time we met long ago and far away when we were all much younger and more energetic and not so jaded and cynical and coming to the end of our third year at university and all the rest of that. You may remember that when I told you a little bit about the course and the trajectory of the course, that I was going to be taking us from formation to the end of the contract. And so now I want to talk about doctrines which vitiate or bring a contract to an end. So I want to spend the rest of today's class talking about vitiating factors. And I'll put that word on the board. Vitiating factors. Vitiating, vitiating factors. Factors which, well, comes from the original Latin word which was vitio, to corrupt or to create as a null and void. factors which bring a contract to an end, which put an end to one or both of the parties' contractual duties to perform their promises. Factors which vitiate, empty out, corrupt in some way. Our word vicious comes from the same Latin root. I always can tell at the final exam who has come to the last class and who has not come to the last class. Because when there is a question about vitiating factors, I always have somebody saying, what does this word mean? So if any of you ask me, I'm not going to answer because you've now heard the meaning of it. And I'm not going to tell the other people either. So make sure you've got it in your mind. I'm going to be really cruel. Okay, vitiating factors. There are really two categories. There are many vitiating factors in contract law, but there's really two categories of this. First of all, factors which vitiate at the time of formation of the contract because there is invalid consent. There is actually no agreement. We hinted at these in the past and often. Yeah. Factors which arise at the time of formation of the contract, which vitiate the contract because there is inappropriate consent. There is no true consent to the agreement. The factors that I'm going to talk about briefly are duress, duress of goods, economic duress, undue influence, unconscionability, and unequal bargaining power. Unequal bargaining power. Duress, duress of goods, economic duress, undue influence, unconscionability, and unequal bargaining power. The other category of vitiating factors are factors which vitiate or bring a contract to an end subsequent to formation. No problems at the time when the contract was made. Valid offer, acceptance, certainty, consideration, blah, blah, blah. Okay? No issues at the time of formation. Okay? But some factors came out of the blue, unforeseen by either party, which makes it impossible to perform their promises that they made to one another. So we're talking about factors which subsequently make contractual performance impossible. And there are two factors here that I want to talk about. One is illegality, sometimes called in the textbooks public policy, illegality or public policy. And the other is frustration of the agreement, frustration of the agreement. Okay, I want to say a little bit about each of these. There are cases on the reading list for the last 2 weeks about them. I think I said don't read them until you see which ones I'm going to do in my lecture and then go back and read them. They're all the short ones, of course, you'll be relieved to know. Okay, they're actually the key ones as well, because older cases tend to be shorter in decisions. Our judges have got very prolix and wordy over time. Okay, yes, this gentleman?
Just to clarify one thing, the 6 factors you mentioned at first, duress, duress of goods, and everything like all those 6, are they before and during formation?
No, just at formation. The first category are factors at formation. Okay, and the second category are factors that arise after formation of the agreement. Okay. In the first category, the issue is there was some kind of problem with the consent. For example, it was procured by duress. Okay? So I'm going to talk about each of these in turn because each focuses on a different type of problem with consent. They're breaking down consent into different types of issues surrounding consent. Okay, so Let's look first of all at the first group of factors, those that arise at the time of formation. First of all, duress. A contract is voidable, and I'll come back to that word in a minute. A contract is voidable if induced by actual or threatened physical violence, if it is induced by actual or threatened physical violence, or unlawful imprisonment of the other party, a near relative, or in the old language, a servant is how it's still framed, but we would probably say an employee today. Okay? A contract is voidable if induced by actual or threatened physical violence or unlawful imprisonment of the other party, a near relative, or a servant/employee. In other words, to put it graphically, when we're talking duress, we're talking about contracts that are made with a gun at my head, and you say, sign or I shoot, okay? Or a gun at my husband's head, and you say, sign or I shoot him, okay? Or at my secretary's head, sign or I shoot her, okay? We're actually talking about contracts made in a violent or with the potential of violent type of violence type of situation. Actual or threatened physical violence or unlawful imprisonment, okay? You know, I'll break your arm if you don't sign. I'll break your other arm if you don't sign, okay? Whatever, okay? Now the impact of obviously there is no consent. And when I have a gun to my head, obviously I'm consenting. Like, what's my choice? Be shot or sign away my life savings, right? We say that's not a real consent, not a real choice. Making a contract means voluntary choice. It really wasn't a voluntary choice. Well, it was a voluntary choice, but it wasn't a voluntary choice. You get the point. Okay, so the effect of signing or agreeing, entering into an agreement as a result of duress, is that the contract is valid but voidable. It gives me the option to avoid the contract. Remember when we talked about misrep and I went rescission and I did the valid but voidable, can be avoided and void scenario? Well, it's the same scenario that fits in here as well. Okay, so the effect is to make the contract voidable. And the other point to remember about duress is that duress need only be one factor. There may be other factors involved in making the contract, but the mere presence of duress is enough to invalidate the agreement. It puts it to an end. Okay? We do not enforce contracts made under duress. Old doctrine. Earliest cases go back to the 12th century. Okay? All are dealing with this kind of situation. Duress of goods. Before I even say any more, if you think it's something about duress not to the person, but to the person's goods, you've got the concept entirely, duress of goods. So in the 18th century, the courts decided to extend the concept of duress to threats to another person's property. To threats to another person's property. If you don't sign this, I'll burn down your house. Okay? If you don't sign this, I'll burn down your house, or I'll trash your car, or heaven forbid, I'll steal your bike. Okay. Now that would be bad. Never be able to talk about it again. Okay. Now the original cases of duress of goods actually involved pawn shops in the 18th century. They involved situations where people took their goods to a pawn shop, and you know essentially how a pawn shop works. You hand your good to the pawnbroker, and he, and it would always have been a he, I think, in the 18th century, he would then give you a loan. You're short of cash, you need some money, so he'll give you £100, $100, whatever it may be. The understanding is that you'll take the money, you'll do whatever it is you had to do with it, and then when you get the money plus the interest that he's going to charge, you'll take your money back and he'll give you your goods back, right? That's how a pawn shop essentially works. So these were cases where the person who was running the pawn shop would say, yeah, I know I was going to only charge you 5% interest, but if you want your goods back, I need 10% interest or 1,000% interest or whatever. I'm going to hold on to the goods, okay, until you pay that extra interest, okay? So where a pawnbroker said something like that, essentially the courts would find duress of goods. And that would mean that the pawnee, that's the person who pawned his goods, is the pawnee, but it sounds like an Indian tribe, so I better change that very quickly. I'll get into deep trouble. So, okay, the person who pawned their goods, the person who pawned their goods would only have to pay the original, under the original agreement, and not pay the excess that the pawnbroker was charging for the return of the goods. So duress of goods. And then it spread out into other types, like if you don't sign, I'll burn down your house or trash your car or whatever, okay? Just not threats involving the person, the physical person of the, sorry, it's a private joke, okay. Not,
No, it's your joke, it's fine.
okay, all right. Not threats involving the physical person of the other party or their relatives, etc., but threats involving their goods and trying to sort of use their goods and hold them hostage, so to speak, in order to procure agreement to enter the agreement. Okay? The third extension of the concept of duress came in the late 20th century. Economic duress. Economic duress. So we're now talking about not duress to the person, not duress to the property of the person, but economic duress, meaning economic pressure, using some kind of economic pressure in order to procure an agreement. Economic pressure which the court finds to be excessive to procure an agreement. Now this area often sort of swings over into consideration. For example, we have agreed that I will, or you will, it doesn't matter, that I will or you will I don't know, my mind has suddenly gone blank. End of term. Sorry?
Can I, well, like, would
Yeah,
that
before,
also,
give me a moment to think of an example. Thanks, go ahead.
I
Yeah.
was just gonna say, would that apply for like employee contracts?
It would, but let me I'll work on that. I just want to use a classic sort of contract situation. Okay. Well, let's just use my bike again, okay? So we've agreed that you're gonna buy my bike for $100, okay? And it's agreed. No pressure, no duress, nothing. We've agreed. We've even got it in writing and we've agreed, okay? Then I come back and say to you, well, you know, I would actually prefer $120 for my bike, okay? Now you could say to me, no, the consideration is $100, right? The consideration is $100. That's what we agreed to. You have to hand over your bike and I'll pay you $100 and there's no $20 about it. But I could be really insistent and say, no, $120. So you can win on consideration, right? Performance of a pre-existing contractual duty issue. But I could somehow put pressure on you, and you must really want my bike for some reason. Okay? You must have to really want my bike, not because it's mine or whatever, but there's something about it that you really want it. And so I use that extra $20 demand as a form of economic pressure that I'm putting on you. Okay? I have somehow figured out that you really want this bike, and I might be able to squeeze 120 out of you for this bike rather than 100. So, you pay 120, and then you go to court and say economic duress. unlawful or excessive economic pressure was put on me. She forced me to pay 20% more than she originally asked for the bike. I want to get that $20 back from her. Economic duress. The real issue about economic duress, and there are examples this lady suggested in the employment context. There are also examples there as well, where employers put pressure on employees. That's right. Yeah. Or employees probably in some situations put pressure on employers to get more out of them. Right?
Yeah.
The real issue in economic duress is knowing what is lawful pressure, okay? Lawful bargaining pressure. We know that when you're negotiating agreement, each party is going to put a little pressure on the other to try and get the best deal they can. The real question is, when does it tip over into pressure which the court will find to be unlawful? Now, if the pressure is pressure that can be characterized as a crime or a tort, well, a crime and a tort are unlawful, right? So that's easy. So some kind of unlawful conduct short of a crime or a tort. When is pressure too much pressure? And so when you look at the cases about economic duress, you see that sometimes the court finds there's too much, other times the court finds there isn't, and just does not, and just enforces the original agreement. So it's always a matter of fact by fact, case by case adjudication by the courts. There have been a number of cases now in Anglo-Canadian common law, probably the best part of 70, 80. And they probably break both ways. Some the courts find economic duress, some don't. It's really a fact-by-fact assessment on the facts of each case. Fourthly, undue influence. Now, in order to understand undue influence and how it arose in the law, we have to go back to the 18th century again. 18th century equity was quite strong. The courts had quite an equitable impulse in the 18th century. In the 18th century, there was just duress, and then duress of goods. But at a time when there was just duress, contracts which were entered into as a result of actual or threatened physical violence. The Court of Chancery, the equity courts, also appreciated that there were other types of pressure that could be put on a person besides physical violence. That is, we could also put psychological pressure. Okay? We could put some kind of psychological pressure on the other party to enter into the agreement. And so the concept of undue influence really focuses not on the actual or threatened physical violence, but on the psychological pressure that could be put on a party to enter into an agreement. So undue influence even today retains its focus on pressure on the mind, pressure on the emotions to enter into an agreement. So we say undue influence then is a kind of form of mental oppression, mental coercion, mental compulsion, in order to secure the consent of the other party. We use words like mental oppression, mental coercion, mental compulsion, to procure the consent of the other party. In a very famous case in the late 19th century, undue influence was very simply defined as the victimization of one party by another. The victimization of the one party by another. And that definition was actually approved by the House of Lords in the late 20th century. So we sometimes work with that undue influence as the victimization of one party by another. Well, that's good. It's nice to have a short, snappy, 6-word definition in the law when we can have a longer, snappy, 6,000-word definition in the law. But the question is always, what is victimization? What amounts to pressure, illegal pressure of one sort or another? Now, the original historical context in which undue influence was found made it easy to know when there was victimization. Because historically in the 18th century, most of the cases where the courts found contracts made as a result of undue influence, they were contracts made between parent and child, solicitor and client, doctor and patient, priest and penitent, okay? They were relationships which were actually fiduciary relationships, relationships where one side, parent, priest, doctor, solicitor, were supposed to act in the best interests of the other side, child, penitent, patient, client, whatever it may be. So in those kinds of situations, one can see where victimization would readily occur. Because a parent would put pressure on the kid, lawyer would put pressure on the client, priest would say, you're going to go to hell unless you make a great donation to my church or whatever, okay? We can see how there was an unequal bargaining power, there was a fiduciary relationship between the parties which could be abused. So we can understand victimization in that context. But over the course of the 20th century, undue influence has come to be applied outside of the fiduciary relationship to other relationships in law. Not often, but also other relationships in law, contractual relationships, employer, employee, okay? Or professional relationships which weren't the historic senior professions, medicine, law, etc. Accountants, clients, engineer, client, architect, client, etc. Okay? The courts are very hesitant to find undue influence, to find victimization, but the principle is there. There certainly are contract cases where it has been found. What types of contract cases? Well, an excellent example is the three-cornered situation that those of you who have done banking law have probably seen. Okay? Bank, husband, wife. Okay? Husband wants loan from bank because of failing company. Bank and husband go to wife and say, please sign this mortgage on house and then we will make loan to husband. Okay? Well, talk about pressure, right? If husband does not get loan from bank, husband's business may fail and then everybody loses everything, right? So in that kind of situation, the courts have sometimes found that the role of the bank, is a very fragile one. They have to set out clearly and professionally the implications if she does not sign the loan, she does not sign the mortgage or the loan agreement to become or guarantee agreement or whatever it is, okay? Without putting influence on her. And the question is, when does the banker go over the line and put influence on her, Does it just involve saying, well, if you don't sign the mortgage or if you don't become a guarantor, this is going to happen? Well, as a matter of fact, that's just a statement of fact. That's what's going to happen, right? That's just what's going to happen. But it could be done in a way that's very a factual statement. It can be done in a way that it can be sort of emotionally loaded, undue influence, victimizing the one. Okay? Fourthly, unconscionability. Unconscionability. Also an equitable doctrine. Also derived in beginning in the 18th century, creation as well.
Sorry, what was it called?
Unconscionability. Number 4, unconscionability. Okay, now, let's just go back again to the 18th century, which wasn't my favorite century, in case you sometimes think, I often go back there, it's the 19th. I very much prefer living in the 21st century, especially with modern medicine and dentistry and standard of living and all the rest of that, right? Who would want to go back to the past? I have to be crazy. Okay. However, let's just go back quickly to the 18th century in order to understand the original paradigm situation in which unconscionability arose. Paradigm situation was the situation of the so-called expectant heir. The expectant heir. expectant heir, which has nothing to do with pregnancy, okay? An expectant heir is a phrase in 19th century or 18th century law, and the expectant heir. Okay, typical fact situation. We had a son, always a son, okay, because women did not own property or could not own property. We have the son of a very well-to-do landed family. Okay. The son, at some stage, when dad pops off, is going to inherit the landed estates, the great castle, whatever, okay? Son needs money, okay? Son goes to money lender. Money lender knows that son is heir to great estate when dad dies. Money lender lends money to expectant heir at exorbitant rates of interest, literally thousands of %, okay? Usurious rates of interest, literally thousands of %. Okay? Son takes money, spends a nice weekend in Paris, etc., whatever, uses it for whatever reason, right? Usually for a life of wine, women, and song. That tends to be the reason, okay, as people used to say. Okay. Now money lender wants money repaid at exorbitant rate of interest. Okay. Son says, but dad is still alive and well, and I don't think he's going to repay, Okay. Money lender goes to court, sues to enforce loan contracts. Money lender loses. Why? Because the courts decide that the loan was unconscionable. It was at a ridiculous rate of interest. It was to somebody who, to a borrower whom the money lender should have known would not be able to repay, etc. The expectant heir. He expects great things when dad dies, or uncle dies, or whoever it is who owns the family fortune, right? He is the expectant heir, okay? But he hasn't come into his estate yet. Cannot repay money lender, and court fines for the expectant heir. Why? They say that the contract of loan was unconscionable. It was, if you like, an abuse of the position of this poor young man, okay? Now, probably the more cynical reason, underlying reason for the courts taking that position was that they could very quickly see the great landed estates of England being broken up in order to repay foolish young men's indebtedness, okay? And I rather suspect because the court, of course, would, many of the property law at that time, many of the doctrines in property law, which we're not talking about here, but many of the doctrines of property law at that time were carved or created in the law so as to protect the transmission of large landed estates for the aristocracy. Okay? That is the cynical reason why we have the doctrine of unconscionability today. Okay? It's not the legal reason, but it's the cynical historical reason as to why we probably have that doctrine today. However, the doctrine enjoyed a renaissance in this. It sort of disappeared in the course of the 19th century. Courts were very reluctant to find contracts to be unconscionable, and the doctrine tended to disappear until the middle of the 20th century. And then unconscionability as a doctrine in contract law came back. And it came back, first of all, in American consumer law. American courts started to say, well, this consumer contract is unconscionable. It's got an exclusion clause, it's got a clause that says this, it's a clause that says that. It is not fair to the consumer. And then it spread from American consumer law in order to protect other types of persons whom the law of contract decided it should start protecting. So it starts to, we see its revival in cases involving contracts which were made with children, which the court finds to be unconscionable. Contracts made with people who mentally challenged, which are found to be unconscionable. Contracts that are made with people who were found to be illiterate and didn't know what it was they were putting an X to. Contracts with people who lacked mental capacity. They were drunk or stoned or whatever when they entered into the contract. In other words, it was revived in order to protect other categories of people who are at a disadvantage and could be taken advantage of when they enter into agreements with parties who know damn well what they're doing, okay? Are trying to get the transfer of some property or money or goods or whatever by getting this disadvantaged person to agree to do so. So today we say unconscionability as a doctrine essentially focuses on three aspects then of the agreement. When do we know a court will apply the doctrine of unconscionability? It will focus on the victim. First, the victim. And we look for a victim who has some kind of bargaining impairment, a bargaining impairment. And I've just gone through their children or their mentally, their mental development issues, or they're drunk or whatever, okay? First, a victim who suffers a bargaining impairment. Secondly, where there is oppressive conduct in creating the contract, oppressive conduct. And thirdly, where there is an oppressive contract as a result. A victim with bargaining impairment, oppressive or unconscionable conduct which procured the agreement, and unconscionable terms resulting in the agreement itself. Okay, so the courts are still reluctant. There are certainly lots of cases in contract law. The courts sort of have a kind of hesitancy. They don't want unconscionability to be sort of everywhere. Otherwise, every contract probably has some kind of element of all of those in it. But we do see an increasing number of those cases as time goes on. But really, we do look to parties who really seem to be not capable of entirely looking after their own interests. And then if they are subject to unconscionable conduct by the party with superior bargaining power, then the court will find the contract unconscionable and it's null and void, will not be enforced. Okay, the final one of these doctrines, vitiating factors at formation, is unequal bargaining power. Unequal bargaining power. Now, I think in 2202 you do Lloyd's Bank and Bundy, right? Remember the case of the old Herbert Bundy and Yew Tree Farm that had been in his family for 300 years, and his son, Michael, whose earth excavation business wasn't doing very well, and the big bad Lloyd's Bank, which loaned him money, and etc. I think you know that case. And you may recall that in that case, Lord Denning came up with a new doctrine. Lord Denning always, as you know, liked new doctrines. A doctrine called unequal bargaining power. And he struck down the agreement between old Herbert Bundy and Lloyd's Bank on the basis, first of all, that there was a breach of fiduciary duty. Lord Denning sort of covered his bottom by using a traditional doctrine. But he also said that there was an unequal bargaining power between old Herbert Bundy and the big bad bank, etc., who had persuaded him to give a series of charges on the family farm and then wanted vacant possession and the loan was not repaid and all that stuff. Okay? Unequal bargaining power. But the question then becomes, what is unequal bargaining power? What are we looking for? As everybody says, every contract is made between parties who have unequal bargaining power. Okay? So I come up to you and say, I want to sell you my bike for $100 and you're a student in my class. You might not actually want my bike, but you might feel, unequal bargaining power, I want to take this course and I need it to get credit to graduate, so I guess I better buy her bike for $100, right? So you might feel that there's a bit of bargaining imbalance here between, professor leaning on student and for the student, etc. Okay? Every contract has that element in it, right? You go to the retail store, and of course the retailer or the manufacturer whose products the retailer is selling, whether it's in store in a bricks and mortar or virtually online, obviously has greater superior bargaining power than you. They know what went into the manufacture of the product. They know whether it was good plastic or bad plastic, good metal or bad metal, okay? Good engineering or bad engineering, okay? They know all that, you don't, okay? So there's always unequal bargaining power in just about every contract that is ever made. But it's not always the people with a lot of money or a lot of authority or superior in some way or a lot of knowledge. It can actually be the other way around. My favorite example is a case which involved a little old lady who, in an area that was being developed, lived on in the family house which she had inherited from her parents, and every time the developer came and said, $1 million for your house, $2 million for your house, $3 million for your house, because he needed that plot of land for whatever it was he was going to build, kept saying no, 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 no. Well, who has superior bargaining power? You would say the little old lady typically should not have superior bargaining power, except she had something that the developer wanted. She had that little plot of land where her family home was, and she was going to try and get as much as she could out of the developer for that. And I've seen that even in sort of a neighborhood adjoining mine. There was an old lady who lived in an old family home for a very long time and managed to get almost $2 million out of a developer who wanted that particular plot of land for her, and you might say more power to her, right? But my point here, of course, is that unequal bargaining power is always there, and even those who don't appear to have bargaining power sometimes do have bargaining power, greater bargaining power than the other side. If you've got something the other side really, really, really wants, you may have superior bargaining power, regardless of any other bargaining impairment which you may have. Okay, so the question became, what does this add to the law of contract? What does this add when we've already got duress and undue influence and unconscionability? And the English courts came to the conclusion it adds absolutely nothing. And so in England, the House of Lords overruled Lloyds Bank and Bundy in a case which those of you who are doing banking law in Nat West and Morgan in 1986, House of Lords, Lord Scarman, overruled Lloyds Bank and Bundy and said it doesn't really add anything. The appropriate doctrine to use when there's an unequal bargaining power and abuse of it is undue influence. Undue influence. Using your superior bargaining power to put psychological pressure on the other party to get the deal you want. Okay? However, unequal bargaining power still exists in Canadian case law. We saw it in Tercon, right? When Mr. Justice Binney was talking about the application of his second test, the second prong of his test, that the contract is unconscionable at the time of formation. He actually exchanges the phrase unconscionable with unequal bargaining power. He said there was no inequality of bargaining power between Tercon and BC, therefore there was no unconscionability. Okay. Now I could point to you, there are no cases, I could actually point to you to lots of other cases in Canadian case law where our courts continue to use this notion of unequal bargaining power, okay, unequal bargaining power. But still, in my view, have not really defined it. But we can say, yes, party X has more bargaining power, they're bigger, they're a multinational corporation or whatever, okay? They've got more money, okay? They've got lawyers working for them, and Y is poor, has to negotiate with some smart-ass lawyer, etc. We can definitely say there's unequal bargaining power. But when do we know we have the kind of unequal bargaining power where the courts will strike down the agreement and say, this is an abuse of bargaining superiority. And then we're into the world of case by case, fact situation by fact situation. And that's the most I can say, okay? It becomes a case by case analysis. Okay, I think it must be just about 1-ish, yes, I'll just have passed, so I better wrap this part up. Okay, so, we've talked then about a whole series of doctrines, which really attack different things: physical abuse, mental abuse, abuse of a position. You can see that they come at this whole area of contract formation from slightly different perspectives, and all complement one another. Okay, so let's take our break now, and then after the break, we'll start at 1:15 sharp. So I think we'll just take a 10-minute. I know it's cruel. We'll just take a 10-minute break.